Good afternoon, everyone. We appreciate everyone for joining us today for this discussion. The primary topic we are going to be exploring is decision Kwong versus United States issued in late 2025 by the U.S. Court of Federal Claims and the decision's potential implications for taxpayers who were charged interest and penalties during the COVID-19 declared national disaster period. First, we should do some introductions. I'm fortunate to be participating in this webinar with Nick Richards of Greenspoon Marder. Nick, you want to take a couple minutes to introduce yourself briefly?
Thank you, Calvin. Always a pleasure to be on these webinars with you and the rest of the team. Yeah, thank you. I am a tax attorney located in beautiful Denver, Colorado. Although today I'm in Florida, and I'm in a hotel room coming to you from my double bed, to tell you the truth. Real happy to be talking about Kwong. I think this is a really big deal. We handle a lot of tax controversy in the space. That means audits and tax court trials and dealing with managing tax court taxpayer debt and stuff like that. And we are seeing this Kwong issue start to show up in our audits as well. We haven't yet heard from the IRS what their position is, but they are pausing a lot of these cases to allow them to get guidance from management and probably IRS counsel as well. So, really excited to be bringing this to our clients today, and it could be a really, really big deal as we'll see as we move forward here.
Yeah, I agree. It's going to be a great discussion and it's a really interesting topic. And yeah, we're happy to get your insight, whether you're from a hotel room or in Colorado. I'm also talking from Colorado. And so, but before we jump into Kwong versus United States, we did briefly want to discuss a very recent development that's probably of interest to any of the cannabis industry participants that are on this call. I'm sure everyone is aware of the DOJ order effective 4/22/26, rescheduling medical cannabis from a Schedule 1 controlled substance to a Schedule 3 controlled substance. This is, very big news and really exciting. I will emphasize at this point, the order does only reclassify medical cannabis, and there is a hearing and possibly more to follow as we proceed into the summer. We're exploring a separate webinar to address several aspects of this development, and we'll be providing more details in the near future. In the meantime, Nick and I, we just wanted to make a couple comments that may be more needed in a timely manner. I guess first and foremost, I'm making the suggestion to all my clients that they hold off on registering their medical license with the DEA until they've had an opportunity to discuss any implications of that with legal counsel. And then, of course, there's a lot of questions around what this means for 280E and having those discussions. And like I said, we may explore that more in a later webinar. But Nick, is there anything more with regard to this DOJ order from last week that you'd like to cover or discuss?
Yeah, so a couple things. One thing is that the order speaks about medical licensees. It doesn't say medical only businesses or anything like that. It just talks about providing relief and rescheduling for medical licensees. And so we believe that dual use companies, adult use and medical, should qualify for, at least partial relief here. Calvin, one of the things that I hear from a lot of my clients in the cannabis space is it's all medical and it's the same plant. How can you classify the same plant as medical in one instance and Schedule 1 in another instance? And I think that's a really good point here. Certainly, I don't know any other situation where there is a drug that has been classified in two different schedules depending upon what it's used for. And I'll even add a little bit more to that. You can go to the grocery store and buy aspirin or Tums, and that's medical. and it doesn't require a prescription. And adult use cannabis could very well be in the very same category. You've got a lot of professionals out there that use adult use cannabis and wouldn't go get a prescription, but will take a gummy or something in the end of the day to relax and use it in a medical way. So I think there's a lot more to kind of fill in here. And I'll also say that the IRS did come out with an announcement on the same day saying they were going to issue some guidance about allocations between medical and adult use. So that seems to be that they're accepting that mixed use companies also can get the benefit of this, and should be able to partially deduct at least some of their costs. The real trick, Calvin, as you know, kind of comes down to mixed costs, right? You have a single dispensary that's used both for medical and adult use. How do you figure out what portion of that is free of Section 280E? And the IRS is going to try to take a very conservative approach there. They'll probably take the approach that it's based upon dollars. And most of these mixed use companies, the medical portion is a real small portion of their overall sales. So we don't like that approach. We think there's a better approach here. Really, the sole difference between medical and adult use cannabis is state taxes. I think almost every state legalized medical first and then allowed adult use later to impose taxes, really. And a lot of medical card holders just let that lapse because then they could go in and buy it adult use. So it's not as simple, I think, as a lot of the folks in the government are thinking here. And I think there's a lot more to accomplish here. And I note there's a 60-day notice and comment period. Everybody in the cannabis industry should be writing a comment, sending it in, and advocating for their business needs here. Particularly, the order also mentioned retrospective relief. Um, Calvin, I think they meant to say retroactive. They said retrospective. I Googled it. Retrospective means the same thing as retroactive. It means to look back. And I think folks in the IRS are saying, oh, well, that means it just applies to all of 2026. I don't think that can be correct because it also says that it applies to all of 2026 in the order as well. And then it goes on to talk about the IRS should also consider retrospective relief. I think that's a nod to what's going on right now in the industry, taking the position that 280E doesn't apply, beginning with Trulieve doing that in 2017 and getting a $150 million refund. So a lot of good stuff here for the cannabis industry. Put your seatbelt on and hold on tight because we don't know where this is going, but we're gonna have to fight for what we believe is right here. It would be my guess.
Yeah, a couple last comments about the um about this order. For one thing, with regard to whether the IRS acquiesced that it should be before 2026 or not, that particular language from the DOJ in their order, I'm wondering how influential that may be, or how impactful that would be for some of the current court cases going on, where people taking the position that 280 hasn't applied for some time. To me, it certainly would seem impactful, but I guess I'm not a lawyer. It's always hard to tell how judges interpret things, but well, I guess we'll see. And like you said, Nick, that we're learning a lot about this every day. We're going to continue learning about it. So everyone should just continue to pay close attention, make comments to the extent you can, and make sure to work with qualified professionals, tax accountants, and lawyers before you do anything. I
And,
guess
and,
is generally my advice.
And Calvin, I just want to say one more thing too. You mentioned you're advising your clients to just hold off before they go and register. I think those are wise words. And I don't know how long we have to hold off, but I don't think it's anything that you want to rush to do. What I believe is true is that if you do get registered as a Schedule 3 provider, you cannot sell or buy from anyone who's not registered Schedule 3. So you may have just lost your adult use portion of your business. And so be careful, folks. Let's give this a little bit for the ink to dry before we rush off and do anything. There's a 60-day window to apply, and you'll get expedited approval within that 60-day window. We're only 4 days or 5 days out on that
Yep.
window, so let's give it a minute.
We've got some time to see what goes, and like I said, most importantly, talk to, qualified legal counsel. Just so you know the implications of what you're getting into, and what the consequences may or may not be. Well, with that, should we revisit the COVID period?
Oh boy.
Shelby, the slides have went away. Can you reshare those again? If not, I suppose I could do it. I'll try to share them then. Can we see the slides here? Nick, can you see them?
Your screen is booting up now. There it is.
Okay. Yeah, very good. All right, I'll just roll through these slides then here. So we did introductions. Now we're talking about Kwong and the COVID period. So how this discussion got started was there was a court case where a tax court judge had or not a judge had provided an opinion that discussed this deadline for or discussed payment or penalties and interest that were going on during the COVID era, and the possible extension of this deadline um, until the end of the COVID period. And the impact of that, what that could mean for due dates for returns during this period, penalties and interest, refund timing. So that's really what had gotten this conversation started. Nick, do you want to make some further comments and really how you see that what this could mean for everyone?
Yeah, so this is the Court of Federal Claims, which is a federal district court. The Court of Federal Claims handles quite a bit of tax cases, actually. And Kwong had filed for some refunds after the 3-year statute to file for refund. The IRS then came back, or the Department of Justice came back and moved to dismiss the cases on summary judgment because they were outside of the statute of limitations. And then Kwong came back and said, "Well, hold on. Those were told during the COVID period." And it wasn't a final decision in the case. It was an order that came down denying the federal government's motion for summary judgment, and then stating what we're going to talk about, the sort of pause that came about during the COVID period. So it isn't we're not sure if it's the law of the land, so to speak, yet. We don't yet know what the IRS position is going to be on it. We have seen in some individual cases some situations where the IRS has agreed to it, but we're not seeing that service wide at this point. And so we're looking for some more guidance from the IRS on this to see how to proceed and whether they're going to just accept it or whether we're gonna have to fight for this.
So at the beginning of this presentation, I had emphasized the word potentially benefit. So this is maybe beneficial, based on how some of this plays out, but certainly worth uh, being aware of and possibly taking some action for some reasons that we'll discuss more as this presentation goes along. So what happened? COVID was treated as a federally declared disaster emergency starting on January 20th, 2020. The language said that the disaster was beginning on and continuing until it ended. What the IRS is what the fight with the IRS is how long the deadlines were paused under the disaster deadline rules. So the key dates that are in question or that we're considering here is when did the COVID really start? January 20th, 2020. What was the period that the COVID emergency ran through? 5/11/2023, and then there's this 60 days add-on. And Nick, well, hopefully you'll give some additional comments about all this, but maybe even more what this 60 days
Yeah.
was about.
Usually, Calvin, we have something like a hurricane, right? And the hurricane comes in and it's a one-day event. And, in those kind of natural disasters, you get a declaration of natural disaster, and it really begins and ends on the same day. And then you have this 60-day period that follows. The difference here is that the disaster was declared on January 20th, and then it existed and it wasn't removed until 60 days before July 10th, 2023. And so the IRS tried to sort of take the same approach that it began and ended on January 20th, 2020, and the court disagreed with them. And created this, man, Calvin, it's a long period, right? It's like 3.5 years or so. And that's, that's a long time. There could be a lot of interest and penalties that were paid in during that year. This could be a lot of money for a lot of people out there.
Yeah, that definitely seems to me like that be the case, or at least worth service providers and taxpayers investigating to see what they did pay as far as penalties and interest goes during that time period.
And Calvin, I think you articulated that earlier when we were talking that extension of time took the 2020 year out to really this summer. I think is the date that we got to on that. Is that right?
Yeah, well, back to this slide, the 30 days ran it to July 10th, 2023. And then we have the 3-year statute beyond July 10th, 2023, which I think gets us to July 10th, 2026, if I'm not mistaken,
Seems
which
right to
is
me.
which is an important date. Well, maybe we should just talk about that a little bit then. So any any penalties that were paid, but let's say any penalties that were paid before July 10th, 2023, can those be refunded? Can you put a claim for a refund in? I believe the answer to that is yes, as long as you do so within the 3-year statute. If the statute does indeed start on July 10th, 2023, then with the 3-year statute would run to July 10th, 2026. And that would be the time frame that you would need to request a refund of any penalties or interest paid.
Sounds right to me, Calvin.
And we're going to talk a little bit more as we move through the presentation about the mechanics of applying for these refunds and different approaches that you may take. But before we do that, I thought we should just quickly review what would be the penalties and interest that could be refunded. And at first, I was hung up on this idea of estimated tax penalties. Is there an argument that those could potentially be refunded? And to me, and Nick, I'd be interested to get your thoughts on this, but it would seem like the requirement to pay estimated taxes was frozen during this period. If
I
this is
agree.
true,
Yeah.
and if that's the case, any estimated tax penalties certainly wouldn't be there. So it seems like there's at least an argument that estimated tax penalties shouldn't apply and could be refunded. And certainly, if returns weren't due and payments weren't due, late payments and late filing penalties wouldn't apply, and any interest associated with uh, late payments would not apply. I don't know, Nick. What do you think?
Yeah, it's kind of tricky, right? Because you could be paying interest for a year prior to 2020 during this
Yeah.
period, which it should apply to any interest paid during the period, or assessed during the period. Should be included as the estimated tax penalties. Some of those for the 2020 year were due in 2019. So it seems like it wouldn't hit that, but it would hit estimated tax payments that were due after um, January 10th, 2020. And then penalties are specific for those 3 years specifically, but interest from penalties from prior years could be included in those years. And then the payment of penalties assessed during those years, but paid after those years should also be included. So it's a pretty wide lens. It's a, as my daughter would say when she's looking at her phone and using her camera, Dad, it's a point five. It's a point five. Um, not a wide angle, Calvin. We don't say that anymore. It's a point five. And yeah, it could be tricky to figure out all of the payments and penalties to which this might apply. So there's some work to do here.
Yeah, it's certain. I think it'd be a case by case, a taxpayer by taxpayer basis where you would go in and look at if any of these penalties or interest would be applicable, and then how much time and energy and service fees would take to figure it out and then proceed and make that decision. You know, working with clients on a case by case basis. So, and we kind of started talking about this before. Um, say the logistics of trying to recover these penalties. And to me, in my mind, it's really two different scenarios. There could be penalties that you've already paid, and those may be penalties. A lot of times, like estimated tax penalties, are paid when you file your return. If they're calculated on the return, and then you get the return along with some payment vouchers saying to pay all of it at once. So those could certainly have been paid then. Also, maybe there's notices, a taxpayer received a notice indicating that there's some penalties and interest due, and it may have been paid then as well. So those are things that are paid, and the mechanism to claim those refunds is probably the best approach would be found in Form 843, or at least to me that's what it seems, Nick. But what do you think?
Yeah, I think that's right. I think this is appropriate for a Form 843 rather than a full amended return or something like that. And it could be that we need to file protective forms 843 rather than actual forms 843. It's hard to say which is right right now. I think the IRS would rather see protective forms. Um, Calvin, I think our clients want to get that money back, which is not a protective form. That's an actual form 843. So I think there's a conversation around that. That feels to me that that's more client specific.
Yeah, and I guess you just have the conversation with the taxpayer and indicate, the IRS may disagree with this and uh, may not pay it. Do you, and this, I guess, is something I thought of. Do you think there'd be any need to get a legal opinion to provide along with the 843, or could it hurt, or maybe probably not all that necessary?
I mean, it could. I don't think it could hurt. I think. I mean, we have a court that's saying this is appropriate. So I'm not 100% sure it's absolutely necessary. I guess if you're a very large taxpayer and we're talking about very large dollars here, maybe it's a good idea to get an opinion. But generally speaking, I wouldn't think there would be a need for an opinion, particularly if you're just filing a protective claim.
Okay. Well, then the other scenario, there very well could be some penalties and interest still outstanding that are applicable to this period that you've been notified, from an IRS notice. What should the approach be to dealing with that?
Yeah. So now you have an argument that you could pay less. There's different ways to get to that. You can file an offer in compromise for doubt as to liability. You could ask you could file an 843 into a collection vehicle. There's a number of different ways to get there. If you have an ongoing matter, you could raise it up with that revenue agent or revenue officer that's part of that ongoing matter. We haven't heard from the IRS how it wants to handle this. The one instance besides Kwong where we did see this come up was in a tax court decision document where they put the Kwong decision, basically what you would call below the line in a decision document. So that was the IRS counsel agreeing to Kwong on the resolution of a case and putting it in the decision document itself, which is very encouraging. Um, but that's just one instance that we've seen so far. We have raised this in some of the audits that we're handling, and the IRS has told us that they'll get back to us.
All right. So again, this is on a case by case basis with each taxpayer. This needs to be considered and reviewed for the facts and circumstances that are specific to that taxpayer.
Yeah. And let me just say, Calvin, there's a claim for abatement of penalties and interest as well that you could file.
Okay. So what to review? Returns and payments originally due between January 20th, 2020 and January 10th, 2023. That probably makes sense. Unpaid balances due on IRS notices. We kind of talked about that. Um, Obtain transcripts from the IRS. So I guess in my mind, this is the most foolproof way to try to ascertain exactly what the penalties and interest that you have paid during this actual period. And Nick and I were talking about, well, what time frame should you ask for transcripts from? And I guess I was originally thinking asking for a transcript from maybe 2020 through today, and looking through each year to try to identify penalties and interest. And Nick brought up the interesting point that maybe it wouldn't hurt just to get transcripts as far back as you can in case there's possibly an unpaid balance from before 2020 that rolled into after 20 January 2020 and interest was accruing. Does that sound about right to you, Nick?
Yeah, Calvin, when people have tax liabilities, sometimes it's hard to know kind of what you pay when. You're getting all these notices and they're showing up. And if you had let's say a 2018 liability and 21 and 23 and you're sending dollars in, it's hard to know where those dollars are going. And it could very well be that there is an opportunity to get relief for a year prior to 2020 if that was paid during the COVID period. So, taxpayers should know kind of at least, hey, gosh, we did have a liability before that, and they could then go get that transcript as well. Um, Calvin, I think you're absolutely right. These transcripts should spell it all out. For those of you who've never seen an account transcript, you have a record with the IRS. It's a record of everything that happens on your social, all the payments, all the assessments, all the accrued interest, any balance dues, all of that stuff is in what's called an account transcript. Actually, the IRS has five or six different kinds of transcripts that you can get. Here, that it is the classic account transcript that you would want to get. Calvin is very prepared to go through all those transcripts with all his clients, line by line, and discuss all the codes and all the fun stuff that's in there. And, you guys should really reach out to him and get on his schedule for that.
Yep, that's a great point because there certainly could be a lot to go through. So getting started on this early as possible would be a good idea. And we are coming up against this July 10th, 2026 deadline that to the extent um, we're going to try to do a protective claim or a regular claim before then. So
Yeah.
the clock's ticking.
And hey, Calvin, let me just say, a protective claim is a claim that is sort of conditioned upon something that could happen in the future. And it's a way to protect your ability to benefit from something that could happen after the statute of limitations expires. And so what the IRS does is they just hold it, and every year you get a letter that says, "Hey, We're holding this protective claim. What do you want us to do with it? Do you want us to go ahead and process it, or do you want to withdraw it? And so it just protects your right to benefit in the future, and then every year you get an ability to pull the trigger on it.
And that protective plan would then stretch it out for another 3 years, I believe.
Calvin, I have never seen, I don't know if a protective claim expires.
Okay.
I haven't seen anything where one has expired. And haven't seen any kind of guidance on that or anything like that. Usually they can go on for 2, 3, 4 years or so, but I think actually they can extend out quite some time.
Okay. Well, that's excellent to know. Questions. So I'll look to see if we have any questions. I don't know, Nick, will I pull up their questions and answers? Do you think a not-for-profit that failed to timely file a Form 990 in the same time frame could get late file penalties abated? To me, I would say absolutely, Nick. What do
I
you
would
think?
agree. Yeah, I would agree. I think that's the classic example. And I would say that applies, outside of not, it applies to 1040s and 1120s and 1065s as well.
Payroll tax forms, 940s, 941s, probably any tax filing would
I,
seem
I don't know why not. I think I would, particularly if you're going to file a protective claim, I think I would be pretty all inclusive on that. Let the IRS say no if they think it's limited to certain kinds of returns.
okay. Well, we've made it through everything. I don't know, Nick, is there any closing comments, or do you think we've covered enough?
I think we're going to see more on this, and I think we're going to have another chance to kind of jump into this and inform our clients about it. So I think we probably have done enough for today. Calvin, I'm sure you're willing to take your client calls, and I'm willing to take mine as well, and talk through this
Absolutely.
as well. And I don't know why everybody out there wouldn't be protecting their hand and trying to set themselves up to benefit from this Kwong case.
Or at a very minimum, exploring if they do have anything to protect for sure, or if it's a significant amount. So, Nick,
Yep.
I really appreciate you taking the time to talk through this for the benefit of all of our clients, and it's been helpful. And as always, appreciate it. Thank you very much.
Thank you, Calvin. Thank you, BGM. Appreciate you as well. Always great.
Talk to you guys later. Everyone have a great day.
You too.